from the control booth in downtown Seattle, where he is all by himself in the WSBA building, pretty much. Okay, go ahead and start recording, Rex. It is 1 p.m. It is April 17th, 2020. We're resuming our WSBA general meeting. We had a great, productive morning, lots of good member feedback and discussion and how the bar moves forward, lots of amazing reports about the fantastic job the WSBA, its executive leadership team, and this board has reacted, and all its committees and volunteers have reacted to the coronavirus. I think we're doing a great job. Let's keep it up. And now we're on to a topic that is directly related to the coronavirus, which is the bar exam, an issue that was raised by the presidents of the student bar associations of the 3 law schools. We have with us as guests the former student body president of Seattle University, Efrain Hudnell, and we have the current student body president of the University of Washington, Amina Dasic. We also have a number of special guests. We have Justice Susan Owens, Justice Steve Gonzalez, Justice Mary Yu, Justice Helen Whitener, newly appointed and sworn to the bench. Congratulations. And Chief Justice Stevens and Justice Gordon MacLeod are present as well. They are taking up this matter, I believe, at their en banc hearing on the 27th. So I thought it was important, since the Board of Governors is going to be hearing from the student perspectives and also from our regulatory council about what's been planned and what alternatives there are, that we have all the decision making people together. And for that end, I will be treating the justices with the same rights as governors as far as the questioning order and time limits, so that they can have all the information they need. As we all know, the Supreme Court is the WSBA's closest and strongest collaborator, and we're so excited to have you here with us. So we'll go ahead and begin. I've asked the students, the student body presidents, to give their presentation first, after which we'll hear from the bar's regulatory department, and then we'll open questions up to the and questions of information to the justices and the governors, and we'll take any public comments, if appropriate, as they come through. So I will turn it over to Mr. Hudnell and Ms. Efrain. Ms. Dasic.
Thank you, Mr. President. Ladies and gentlemen of the Board of Governors, Madam Chief Justice, Justices of the Washington Supreme Court. Again, my name is Efrain Hudnell. I'm a third-year student at Seattle University School of Law. I'm also joined by my colleagues and fellow proponents. If they could please introduce themselves at this time.
Hello, everyone. As previously mentioned, my name is Amina Dasic, and I'm currently the SA president from the University of Washington School of Law. Just quickly to note, I wanted to just say that our 3L reps are also present on the call, Adam Griffiths and Meredith Ruff, in support on behalf of the 3L class at UW.
Hi, everybody. Excuse me, sorry. My name is Daniel Coombe. I'm also a third-year student. I apologize for the background. I'm at the airport because my flights were canceled because of the coronavirus. I was originally supposed to be in Seattle today for this meeting, but I represent out-of-state students who intend to practice in Washington State.
Wonderful.
Also, is Ms. Grace Maldonado from Gonzaga University School of Law, also of the class 2020, could not join us here today. She's the current Student Bar Association president there. We come to you today on behalf of a collective of law students and members of our legal community concerning the July uniform bar examination. Several states have already postponed the UBE or are allowing for temporary licensure in favor of practicing and on conditions of eventual passage of the UBE. We stress that both of these courses of actions would cause undue hardship to the class, our prospective employers, and the communities that we seek to serve. As you may know, our collective has already circulated a petition which can be found on pages 56 through 65 of your agenda meeting materials. These materials call attention to our situation and ask for something called diploma privilege, should conditions threaten the safe administration of the UBE. We understand that diploma privilege is a broad concept and that there have been questions about what exactly the collective is asking for. So we'd like to start by clarifying what we are not asking for. We are not asking for the UBE to be canceled outright. We are not asking for diploma privilege with respect to the Multi-State Professional Responsibility Examination, or MPRE, Character and Fitness Evaluation, or the Washington Law component. What we are asking for is this: if and only if the Uniform Bar Examination cannot be safely administered in July, the class of 2020 should be granted diploma privilege over that requirement for admission to the bar so that we can get to work. We don't question the legitimate benefit of exposing graduates to substantive law in preparation for the bar exam. But when does the value added by this examination become outweighed by the costs of administering it during a global health crisis? It is our position that if exposure to substantive law is the end goal, then there are other ways to meet that goal. If we cannot commit to diploma privilege as a contingency now, then we ask that you allow us to partner with you so that we can help inform the most equitable outcome moving forward. Thank you. That concludes our prepared remarks this time, Mr. President.
Thank you very much. Ms. Dasick, did you have anything to add to that?
No, we would like to answer any questions that anyone may have, but we wanted to keep this short and simple to allow for a conversation.
Very, very, very wise, good lawyering skills already developed. Thank you so much. And now we're gonna come back to the students, but we're gonna also hear from Chief Regulatory Counsel Jean Mcelroy. I've seen her there in one of my Brady Bunch boxes, and I'll also let everyone know that a few more governors have joined us, as has Justice Raquel Montoya. Thank you, Chief. But you're muted, Chief.
Are you calling on Chief Regulatory Counsel Jean Mcelroy? That's what I understood.
Oh, yeah, yes, Chief Justice. Thank you.
So I'll just be quiet.
There's a few chiefs running around here. I'll try to be more specific.
Good afternoon. I'm Jean Mcelroy, Chief Regulatory Counsel for the Washington State Bar Association. I am here primarily to answer questions and provide additional background about what is happening and what is possible to happen with respect to the Uniform Bar Exam administration in July of this year. I have submitted a number of materials that discuss the various rules that imply or directly state that a Uniform Bar Exam score and exam are required for full admission and licensing in Washington. I've also provided in my materials a discussion about Washington's Admission and Practice Rule 9, which is in fact includes a limited practice license for recent graduates of law schools. Recent graduates can practice for up to 18 months under this license, under the supervision of a lawyer, and it is not conditioned on having to be signed up to take the bar exam, and failing the bar exam does not require that you lose this license. The reason I emphasize those 2 points is because if you look in some of the materials that came in the late materials, there is a summary of provisions that are in existence in other states. Many of those provisions for either a provisional license or a limited license, most of them call it a limited graduate license, contain a provision that if you fail the bar exam, you lose your license. And so Washington's approach we have tried to be open and welcoming to law school students, to people from not just ABA accredited law schools, but also our law clerk program, APR 6 program, and also to people who have a non-ABA JD and they can take the LLM degree for the practice of law and then qualify to take the bar exam that way. Also for lawyers who are licensed in another country, who can qualify in one of 2 ways, one of those being completing the LLM degree for the practice of law, and then that qualifies them to take the bar exam. And so we have tried to be inclusive in those ways to make sure that we can draw new attorneys from the broadest group of people possible. And we've also recognized that there is a hard impact on people if they, while they're waiting to get their actual full admission to license, if they can't to practice law, if they can't practice in the meantime. And also the fact that it seems unduly harsh to say that you take and fail the bar exam, and even though you could fit a second administration in during that same time, you immediately would lose your Rule 9 license. I do have a couple of pieces of new information. One is that in a communication yesterday, it was made clear by the NCBE that states can offer both a July examination and one fall examination, and applicants can take one or the other. And the reason that is exciting is because that might be a good compromise. It is an expensive, probably the most expensive of the compromises, but that might be a good approach, because then those who really need to take the exam in July and are very interested in that would be able to do that. And other people who would not be able to do that could opt to take the exam in September. I really want to call out our admissions manager, Gus Quinones, who is just top notch. I couldn't say enough in his praise. He and the admissions analysts and other RSD staff stand ready to do whatever it takes to be able to put on a safe and qualifying exam, if that's the decision, to help applicants to be licensed in the meantime under the Rule 9 license, and to essentially put into place whatever decision is reached. I did want to emphasize also that in my memo, I may have made it sound like the Utah court had actually adopted a rule allowing diploma privilege. It's a very qualified diploma privilege, but in addition, it wasn't actually adopted yet. They were accepting comments until yesterday, and I have not heard today that it's been adopted. It's an interesting compromise in a number of ways. It allows diploma privilege only to those graduates of an ABA accredited law school with a pass rate on the July 2019 of 86% or higher, which leaves out a lot of law schools. It also leaves out people who have failed the exam previously. And it requires a period of supervised practice in addition to everything else. So again, I don't know whether that will be adopted in Utah, but I wanted to clarify that, make sure that everyone understood it. Many states have opted to continue their exam until the fall. The most popular fall date seems to be September 9th and 10th, although there are some opting for the September 30th and October 1st dates. And I'm happy to answer any questions if you have them.
Just a few points of clarification. First, Justice Gonzalez let the chat room know that the Supreme Court's en banc is on the 29th, not the 27th, like I said earlier. And then Chief McElroy, at the moment, the bar is planning to host the bar exam. Is that correct?
Get myself unmuted. Yes, we are scheduled to hold it in July. We have contracts in place. We will take whatever actions are necessary in order to comply with social distancing and other health regulations in existence at the time. If that means reserving other spaces so that we can divide into smaller groups, we will do that. And it will mean hiring some additional proctors. It will mean some additional measures that need to be put in place. I do want to say that the National Conference of Bar Examiners has been extremely responsive to the requirements, the questions from the states, and they are looking at easing some of their security requirements, including if you wear a mask, a face mask, not requiring people to take that off, thank goodness, and some other things like that. Those are all under discussion at the National Conference of Bar Examiners level.
Wonderful. And Ms. Dasick, did you have some comments you wanted to add?
Just a few clarifying questions. Is the Washington State Bar Exam Association 100% set on continuing with taking or with administering the July bar exam, or are there alternative options that can be considered? Because our whole point is that diploma privilege and potentially the supervised practice is the best option. But regardless of that, LSAT has just moved online and they're able to administer it remotely. Have you guys considered administering an online exam in the same way that the LSAT will be?
So, Washington is a uniform bar exam state. Oh, sorry, I just jumped in to answer. Is that okay?
No, I actually subtly nodded my head towards you. But
I must have seen it. Washington is a uniform bar exam state, and the uniform bar exam is prepared and overseen by the National Conference of Bar Examiners. We cannot currently use remote proctoring because of the security risks associated with disclosure of exam items, and because there are a lot of reasons. There are problems with making sure people receive the special accommodations that they require for test taking. There are problems with exam security. There are problems with making sure that people aren't cheating. Washington applicants have been very good about that, so we try not to talk about it much, but it is a possibility and it does exist. There are other possibilities being considered by the National Conference of Bar Examiners. We here at the Bar Association do not make the decision about whether there will be a bar exam or not. We follow the rules and court orders, and so that is entirely up to the court. I did want to emphasize once again that the Rule 9 graduate practice license already exists, and anybody can apply for that who is either a law student who meets the fulfillment requirements, a law clerk in the program, or even a graduate of law school. If they haven't applied previously, they would have to apply within 9 months of graduation, but that seems reasonable in light of the fact that if they've taken and failed the winter exam, they've already applied for admission. So it would be just as easy to apply for a Rule 9 license in the meantime. And what many states are looking at for their supervised practice is something very similar to our Rule 9, only more restrictive. Losing the license if you fail the exam, having it be for a shorter period of time, and not allowing additional types of practice or scope of practice beyond what we allow. I did in my memo talk about some ideas that I raised regarding issues with the current Rule 9, one of them having to do with the law clerk program, which is that there is a conflict between two provisions in the rules, one of which implies that an APR 6 law clerk would not qualify for a Rule 9 license after they finish the law clerk program. And it would just be very helpful if we clarified that. And also suggesting that if people think that 18 months is too short a period to have this license, asking the court if the court would consider extending that period of time. But it is the longest period that I've seen among any of the graduate practice rules.
Thank you, Chief McElroy. I have this following list that I'm about to tell people so they don't get too anxious. I have Director Nevitt. I have Justice Gonzalez. I have Governor Stevens. I have Governor Abell. And then I have former Governor Cherry. So, Director Nevitt, if you'd please proceed.
Sure. Just briefly, I just wanted to emphasize on the heels of Chief McElroy's comments to your first question, whether we're 100% committed to offering the July exam. I think until we receive contrary direction, we are, but only to the extent that it can be held safely. We're not sure what kind of social distancing orders we will be under at that time. So I hope it's obvious, but I just want to clarify that if we get closer and we realize it cannot be held safely, we will not hold it.
And Director Nevitt, since I have you speaking, could you read the public comment that just came in? There's a question from the public, and it might be a question many people have.
Yes, give me 1 second here. Okay. Question to woman speaking about Rule 9 for a maximum of 18 months. How would this work for law students who have been participating in Rule 9 externships for quite some time already? I think that's to you, Chief.
Yes. So there is a maximum consecutive time period for the Rule 9 license of 30 months. You have to be in your second year of law school in order to qualify for a Rule 9 license. You have to, or else be in your, have completed, I believe it's 4/5 of your law clerk program in order to qualify. So 30 months total would get you out pretty close to 18 months. But again, if that's something that the court would feel it was appropriate to extend during this period, that would be a great thing to consider.
Thank you, Chief. Next, we have Justice Stevens.
Actually, Rajiv, I think you had
I
just.
apologize. I read
You keep
Steve
trying to call on
and
me.
said came the word Stevens came out, but Justice Steve Gonzalez.
Thank you. That's all right. I misspeak all the time. I wanted to say a couple of things. One, I recognize that the bar takes the administration of the exam and the admission process seriously, as it should, and is ready to make the test available if that's the order of the court for people who want to take the bar. My concern, though, in the assertions that everything will be done to keep it safe, is that perhaps the travel component hasn't been factored in. And I'm wondering if there's any way to safely travel to and from. And for many people who don't live close by, they want to stay somewhere, maybe a hotel, et cetera. So we're talking about flights, trains, buses, hotel, et cetera, and then the need to get food during that time. When you talked about the safety planning and the determination about whether it will be safe, have you factored in those considerations? And then before I give up the mic, given the rules that I only get to speak once, I also had a question for the students. What are your thoughts about reciprocity if we were to follow this recommendation? And what would the plan be for people who maybe got the diploma privilege but later wanted to take the bar examination? How would you propose that be addressed if your proposal is followed? Thank you.
Let's go ahead with the let's go Chief McElroy on the first question. We'll go with the students on the second question, but just point of information, everyone will be able to speak additional times as soon as everyone's had an opportunity.
Thank you. In light of the travel restrictions and so on, if it's not safe to travel, if there are orders or rules or whatever in place that people can't travel, obviously that's something that would be taken into account in determining whether the bar exam can be administered safely. Normally we do not administer the bar exam in more than one general location. We have the main site, which lately has been the Tacoma Convention Center, but it hasn't always been. And we have a special accommodations site, which is close by within blocks. We don't generally go out into other areas to administer the exam, other areas of the state. However, in extraordinary times, there might be need for extraordinary actions, and certainly that would be something that could be considered. And I would add that normally the National Conference of Bar Examiners does not think that it's a great idea to do that. Again, in the discussion yesterday, they made it clear that in easing some of their security restrictions, that was another one that they were thinking might be able to be eased, would be to have it in different locations.
Thank you. And then just to restate Justice Gonzalez's question, Justice Gonzalez, please correct me if I'm misstating it, but Justice Gonzalez's question for the students in their proposal was specifically in regards to reciprocity. That means if students want to be admitted later into another state, it's usually a requirement of that state that they've passed the bar exam. Is that correct, Justice Gonzalez? Great. So if you have any thoughts about that.
Very briefly, and then I'll want to kick it over to Daniel since he's representing the out-of-state perspective. Right now, our proposal doesn't cover reciprocity. Simply, it's geared towards those seeking to practice law here in the state of Washington. We imagine that it is a fact that other states are grappling with the same issue simultaneous to us. So that we're not the only ones talking about reciprocity right now and the ability to practice in those jurisdictions. But that is second to the ability to practice in the first place. Daniel, did you have any comments on this?
Yeah, obviously, I'm so sorry if there's background noise here, but the reciprocity issue, I think, is up to the individual states to handle. But that's why I think we need the support of the bar, we need the support of the court for students so that they can be represented at a higher federal level. So there's a collective response to this. I understand that the bar exam is under the jurisdiction of each individual state, but that doesn't preclude the ability for state leaders such as this wonderful bar and courts to work with higher level organizations so a more collective response can be made. But it is a serious issue, and I don't think that any solution revolving the diploma privilege can tackle reciprocity head on. It'll have to be a political response at the national level, and I think that's certainly something that folks here who have such clout and expertise could certainly take part in a conversation like that.
Thank you.
Thank you. Next, we have Governor Alex Stevens.
Thank you, Mr. President. This is actually for the 3 Ls that are here. So I understand you are proposing and supporting diploma privilege, but Chief Regulatory Officer has mentioned Rule 9. I would like you to address why that would not work, or why you would not support that, or why that would not be a suitable alternative. I'd just like to hear you on that.
It's a very good question. Rule 9 does get us in the courtroom. What Rule 9 does not do is it doesn't get us status as full-time employees. Most employers don't treat Rule 9s like they do a fully licensed attorney. This is especially so in the public sector. I work for a prosecutor's office right now. As a Rule 9, I don't get paid. I don't get health insurance. I don't get anything, and I don't imagine that's going to change if we just allow us to practice under Rule 9. It becomes employer dependent at that point, and only furthers the hardship to be felt. I mean, and currently graduates wait 3 to 4 months after graduation before they can start to practice and pull a full-time paycheck. Now we're looking at in excess of 6 months. That's untenable. So many of us would have to seek jobs outside of the public sector just to make ends meet, or pick up a second career as a bartender or something just to pull in an income.
Right. In addition to that, thank you, Efrain. Part of that Rule 9 status and being able to switch on to taking the bar exam depends on the flexibility and compassion and understanding, as well as the resourcefulness of our employers, whether those are private or public employers. And so I don't think the Rule 9 solution is it's impossible. It certainly can work. It will, though, cause a lot of disruption for those who are already full steam ahead in their careers. And as some of as all of us know here who have worked in firms, very hard to take time off in the middle of a trial or transaction or deal to go back and study. And I'm sure it impacts the entire class in general in terms of how favorable we look as future employees firms if we have to go back and stop.
I just want to add a few more points about that. Extension of like Rule 9 licenses would be very burdensome to employers who hire law graduates with the expectation that they'd be able to practice law without supervision. They won't be able to submit certain documents to the court without having someone supervising them. And additionally, it brings into question a lot of the different factors of who can actually afford to just do Rule 9 licensing without payment. Who are those people privileged enough to be able to do work without having to get an income? And there's a lot more issues, I think, that really need to be considered if Rule 9 is an option. Utah, for example, I understand their model may not be perfect, but they do allow for diploma privilege plus option, which allows them to allow students to have the diploma privilege and then essentially get a certification within 360 hours of supervised work. And if Rule 9 can be formatted to kind of allow for that as well and not have to force individuals to stop work to take the bar exam, then it may be a possible option. But I do think that we need to consider all the other levels of it too.
Mr. President?
Yes,
Mr.
Governor
President,
Stevens.
may I ask the follow-up?
Please.
Okay, so I also want to understand that if we were to adopt your proposal, are you in a sense grandfathered in for all time without having to come back and take a bar exam when we're out from under this emergency? How is that? I just want to understand, long term, what that means for allowing you to practice law and be paid, et cetera, and then we go back. Are you just kind of grandfathered out of having to take the bar exam at all?
Yes, under our proposal, the answer simply is yes. Currently, it is recommended to study for the bar. We take 2 months, studying 50 hours a week, 8 hours a day, 6 days a week to prepare for the bar examination. Having to take the bar exam after a certain period of time in practice assumes that we will have the ability to take time off to prepare for the bar exam. This doesn't compute. This doesn't impute by nature of the proposal. Imagine a public defender. It's the classic example. You're taking on a caseload more than you probably should be, zealously advocating for your clients. Now you've been in practice for a year and it's time to go back to the books and prepare for the bar examination. You don't have the paid time leave up. You don't have 2 months of paid leave to take time off. So you're either at the mercy of your employer, the public defense office, if they have the resources to give you the time off to study, or you're balancing a workload while studying for the bar exam. There are countless examples of this that would be felt across the state, and we're ultimately looking at people not passing the bar because they can't balance a workload with passing the bar because it's not meant to be that way. That's my response to that question.
Thank you. Okay, just let people know where we are in the order of things so they don't get too antsy. I have Governor Abell, former Governor Cherry, Justice Gordon MacLeod, Governor Knight, Governor Schicchetti, but Chief McElroy, you may have some things to add, is that correct? I'll jump you in the line and then we'll move on to Governor Abell.
Thank you. I just wanted to provide a comment about the Rule 9 license because there's nothing about the Rule 9 license that says you can't be paid. There's, many people work in full-time paid positions as Rule 9 license holders, and that has been the case for a long time. I mean, since before I took the bar exam, during which time I did work as a Rule 9 licensed person for the bar exam while I was studying for it. So it's been in existence for a long time. And this is not something new that would need to be introduced. I do think there could be some ways that it could be improved. For instance, right now, one private practice lawyer or one lawyer can supervise one intern. And that number could potentially be increased so that if there's more than one lawyer, that more than one intern that a lawyer would like to supervise, that would be permitted. The other possibility is to make some sort of an exception for practice with legal aid organizations. In reviewing rules from other states, there was one state that had an interesting rule about practicing with a legal aid organization and how many people could be supervised. Many other states limit the practice of their graduate licensees to only public and employment and legal aid employment, and Washington does not. You can work for private practice lawyer as well as a public agency.
Thank you, Chief. We'll move on to Governor Abell.
Thank you, Mr. President. A quick observation and then a question for Chief Regulatory Counsel Mcelroy. So my observation to the law students is that you delivered a superb presentation. Thank you for being here. I will also say that this presentation, your petition, is a welcome vehicle for us to bring this issue to the fore. I know that President Majumdar and Interim Executive Director Nevitt have been talking and thinking about this issue for some time. This is a great way for all of us to address this. My question for Jean is a question about timing. So your written materials were very helpful. I appreciate it, and I apologize if I missed it in there. But do you have a recommendation for us and the court about, frankly, when this decision is made? And in my asking that, I realize that there's value in making this decision sooner rather than later. At the same time, conditions are changing from week to week, and it strikes me that if we're going to go away from what I'm kind of thinking of Plan A, the idea that we have the July bar exam as scheduled and as we have in the past, that there's probably an optimum window for us to make the decision to go away from Plan A, both as a cost matter, both as an organizational matter, and then allowing the law students efficient time to study. Do you have a thought as to when that optimum window would close? Thank you.
I don't have a specific date, but I would note that we do have a hold on the Tacoma Convention Center for the September 30th and October 1st dates. So that is a viable option if the July date can't work. The other possibility, as I mentioned, that's now available, is to offer it on July and another date, so that thereby it would be easier to accommodate smaller numbers. If there's a limitation of, say, 50 people in a room or in a gathering, an event at that time, which was one of the interim steps before we got to the stay-at-home order, it would be easier to do that if we're administering the exam on two different dates. I'd say probably June, early June at the latest would be helpful for us.
Thank you.
In terms of contracting.
Thank you.
Former Governor Cherry.
I have two questions, please, and SBA President Hudnall.
And just to pause, former Governor Cherry is also on the Practice of Law Board, which explains some interest.
Thank you, and I have some thoughts from the Practice of Law Board perspective, but I think I'll save those for another time. Again, SBA President Hudnall, are you guys, your brief was very well written, and I tried to read it last night and didn't get all the way through it, and I apologize for that. But is there any discussion of whether or not, and I don't know if you've reached out to the malpractice underwriters to see if they would underwrite a diploma privilege attorney? I know in Washington State we do not mandate on a malpractice in insurance, but many of our firms have it. I have it, and I would need to check with. I mean, I could not hire somebody unless they could be underwritten for insurance. It just would be a policy that I have. So, have you reached out to any of the underwriters to see if they would underwrite malpractice insurance for a diploma privileged attorney?
That's a great question. No, we have not. This is obviously moving incredibly fast. We didn't get organized until April 1st, which is no excuse. But now that you have raised that concern, that would definitely be the next steps that we would take.
And again, I acknowledge it's not a mandated requirement in Washington, but I think it would be an issue for those firms that have a policy. My second question is this, and I again missed this if it was raised, but is this a blanket diploma privilege, or was there some GPA, some grade level, some acknowledgement of performance in law school that you were considering?
Our petition does not consider individual performances nor performance of the law school itself, only that the law student be a graduate of a ABA accredited law school in 2020 and be registered and plan to sit for the July 2020 uniform bar examination.
Let me thank you for bringing this matter forward. Let me empathize with you. Although I know I look like an old attorney, I am only been practicing law for the last 6 years. And so taking the bar exam is still very much on my mind, and something that I still remember it's still very much in my mind. So I empathize with you. This is a hard position to be in right now. And so please stay as strong as you can and as focused as you can on getting to your career. Thank you.
Thank you, former Governor Cherry. Next, we're going to have Justice Gordon MacLeod, followed by Governor Knight, followed by Governor Cicchetti, followed by Justice Mary Yu. But Chief McElroy, did you have some more information to contribute first?
No, actually, I had some questions I wanted to ask the students.
And I'll put you in the queue then.
Thank you.
Justice MacLeod, please proceed.
Thanks. I'm undecided on this issue, and I agree with, I think it was Governor Abel who said that this arises in the context of the broader question of the value of the bar exam in general. And I've heard that debated for years. Here's my question for the proponents of this rule and also for our regulatory counsel. Seems to me that there's good arguments for not giving the bar exam this summer to this crop of students, basically health and safety concerns. And then there's all the arguments about why the bar exam is not the best vehicle to determine who's going to be the lawyers that we want practicing. On the other hand, we haven't made a big decision on that either. What do you think of diploma privilege for this crop of students? And then evaluating a few years hence, how did it turn out? How did this crop of students perform on whatever we think are the ways that we should evaluate lawyers? Discipline, on the negative side, disciplinary problems, malpractice problems, ineffective assistance problems. On the positive side, contributions to the profession, contributions to pro bono work, achievements, actually practicing law rather than not practicing law. Doesn't this give us an opportunity to have a control group from which we can take a look back in the future and say, boy, that seemed to work out fine, or boy, that was a real mistake. Let's not ever adopt that outcome. I mean, that's the question.
And if I may very briefly clarify, the question is, if diploma privilege is granted to this class, would we be amenable to being the quote unquote guinea pigs for a subsequent evaluation on the merits of future administrations of the bar exam?
That's half the question, and I guess the other half of the question would be for regulatory counsel and people opposing diploma privilege about what would be the downside to that.
Mr. President, if I may briefly,
Please.
Simply put, we're definitely, I think we're amenable to it. I think our chief concern is being able to practice law when we are needed most. And if that be conditioned on us being evaluated as a class after the fact, then so be it. But we don't take issue with the bar examination per se. We only take issue with the administration of the bar examination in these times, in that it would cause undue hardship for us, as well as our employers and the communities that we're seeking to serve.
Chief McElroy, do you have any comments about the guinea pig question?
Well, yeah. And I want to be clear, I'm trying very hard not to take a position and just to provide background information because I don't have a strongly held position other than I have to follow the rules and court orders. And I do think people need to understand the Rule 9 provisions because I do think that's important. But I do, and this gets to my questions. It's like, well, so what do we do with the applicants who took and failed the February exam, who also graduated in 2020 from the same law schools as you folks did, and yet they've failed the bar exam? So that's question number one. Question number two is, are you talking only about diploma privilege for people who've graduated from the Washington law schools, or everybody from around the country? And are you talking about only for ABA accredited law schools or all law schools? Because currently we have provisions that allow people from all law schools to find a path to get them into the legal profession. And also, you know, as I pointed out, the Utah rule has a provision for an 86% pass rate on the last July bar exam, which I think would cut out a number of schools, including I believe, the 3 Washington law schools.
Just to jump in, University of Washington has a 90% bar passage rate. Seattle U has about 76%, and Gonzaga, I believe, is above 86% as well. And we don't believe that that percentage rate should be looked at. I do think that for us, it was more of like ABA accredited law schools and keeping it at that and making sure that you graduated from one of those law schools and that you would then be able to get diploma privilege.
Right, Your Honor, and if I don't mind jumping in, I thank you for asking that question. I also want to stress the outcomes don't have to be mutually exclusive in the sense that we either let the floodgates open or we go the original way. We believe there are creative solutions that could mitigate the possibility that we let people into the bar who shouldn't be admitted. I'm sure there are multiple forms of criteria we could look at that and administer them in a way that's equitable and fair and both responsive to the public health crisis that we're facing.
Governor Knight.
Thank you, President Majumdar. And I want to thank the law school presenters. Excellent presentation and excellent written materials. What I'd like to do is share with you some of the concerns that I've heard about the diploma privilege and give you an opportunity to weigh in on those concerns. And perhaps you have some safeguards in place, or perhaps there are issues that have not been thought about yet. Some of these concerns I think are practical and some are somewhat theoretical. But I think there are 3 concerns. And the first is, are you at all concerned about the protection of the public? What safeguards are in place to ensure that the WSBA does not license individuals that do not meet a minimum level of competence that the bar exam may measure? The second concern, I'd like to add on to Justice Gonzalez's question about reciprocity. Let's say that the WSBA grants diploma privilege to all 2020 graduates. They become members of the WSBA. 2 years from now, one of them wants to waive into another state, but they must take the bar exam to do that. So they take the bar exam, but they get a score lower than the Washington threshold. Is their Washington license suspended? They've demonstrated an inability to meet that threshold. You know, what are your thoughts about that? And the third thought is really kind of very theoretical, but do you have any concerns that some members of the practice or public will sort of view the class of 2020 as not real lawyers because they haven't taken the bar exam that every other lawyer has, and that you'll be categorized in a different category than everyone before you, and assuming this crisis passes, everyone after you? So if you can give some thoughts on those three topics, I'd appreciate it.
Yeah, just to jump in real quick on your last point, I actually have a comment from a student on your third question. She said that some students have raised concerns about being discriminated against in the legal market if we get diploma privilege. We honestly think this position is ridiculous, but our thought is that students who want to take the bar can go ahead and take it later. And that's from a 3L at UW Law. So I think that that's the trend that I've been getting and soliciting comments from the class. And I just don't think that that's a big concern of theirs. I think their biggest concern is the global pandemic that's happening right now and how they can get to work as soon as possible, how they can get healthcare, how they can get a job. And I think the last thing they're going to be worried about is the last thing they're going to be worried about is whether or not they can compete in a legal market where many of them are very talented and able.
Thank you. We're going to move on to Governor Shichetti.
Thank you. I had two questions. One of my questions may have already been answered, so I'm going to restate it and then ask if my understanding is correct. Many years ago, I attended law school, and but in another state, and I plan to return to Washington to actually practice. And so my proposal is that out of law schools, provided that they're accredited, be able to assert the privilege as to the Washington State Bar. Is that correct?
I'm sorry, Mr. Governor, you broke up a little bit. Could you repeat that question?
Yes, sorry. Many years ago, I graduated from law school in a different state, and I had planned to return to Washington to actually practice. And I took the bar exam 2 states, but Washington being one of them. In your proposal, would it be correct to assume that those folks who are in out-of-state schools could still then utilize the diploma privilege to become active in the Washington State Bar? Is that correct?
All right, I think in your question to be one of reciprocity again, and our proposal is agnostic towards the treatment of other individuals who are licensed in other states to Washington and vice versa. Namely, we're just concerned being able to practice in the first place. I think it was mentioned in a previous comment by Ms. Health insurance, money now, getting paid now, and pay student loans when they turn back on in September. That's a chief concern here. That is absolute concern, reciprocity practice in other districts or jurisdictions, but that is being able to practice in the first place.
I think I can simplify Governor Shichetti's question. Does this diploma privilege only extend to the 3 law schools in Washington or to all ABA accredited law?
I think I should answer this question since I'm the one out-of-stater in this conversation. For background, I go to Northwestern Law School right now, and I'm currently at Chicago Airport trying to come back to Seattle. But we do think that it should apply to students who are planning and have already registered for the July bar exam. There could be discussions to open it further, but we don't see a good reason to exclude other qualified students or law schools, for that matter, that are just as competent to practice law as the 3 law schools in Washington State. And there could be a variety of ways of bettering out which schools may not qualify, for example, ABA accreditation. But no, we don't see a good reason to exclude other qualified students if into that.
And that was my understanding. Thank you for clarifying. My follow-up question was, earlier this month, the ABA came out with a resolution for the limited authority to practice law. Have you reviewed that resolution? Do you have any thoughts on why that would work?
Yeah, we've actually reviewed it, and we do believe that the ABA did try to address a lot of the many different concerns. And at this moment, we will be in support of something like that as well. I think that for us, we really just want to find the option that's going to impact the least amount of people and get people working as soon as possible. So if that means that we go with the ABA's recommended limited supervision way, I think that that's what some students would be okay with.
Thank you.
And just for the record, can someone tell us where the ABA resolution is in the materials for everyone's reference?
It's in materials, page 34, and it goes through quite a ways. There's some attachments, some exhibits. I think it goes all the way to limited late materials, perhaps 90.
Late materials, page 34 for people's reference later and contemplation or later discussion in this session. Now we're going to go to Justice Mary Yu.
There was a point where the sound wasn't so perfect at my end, and I'm not quite sure I heard an answer to the question about whether or not there might be individuals who registered for the exam that may be taking it for the second or third time because of prior failures. Are they included in this proposal? That's one question. And I thought that was posed by Jean McElroy, and I just didn't hear the answer to that. The second is, I was wondering if you might address the plight of LLMs who are allowed to take the exam, but don't come necessarily from an accredited law school. They don't have that JD.
Thank you for that question, Madam Justice. With respect to the outliers question, those who would be a second or third time repeat bar exam taker, our proposal doesn't, unfortunately, is agnostic towards them as individuals. That really exceeds our expertise when it comes to administering exams and those who should be eligible, should be waived. Frankly, our proposal is considering the overwhelming majority of students, first-time takers, and by no fault of their own, are being barred from the practice of law simply because of the timing of their graduation. If a second or third time student is excluded, it's something that unfortunately, it's not something that we've been able to resolve in our own collective discussions as students, and we would defer to the expertise of the Regulatory Council and the experts here. With respect to LLMs, I unfortunately don't have a prepared talking point for LLMs. I wonder if Amina or Daniel might have something that they can offer.
Well, I think
if you do, please proceed.
Sure. I think as we stated a little bit before, I think even if some students failed the bar exam a few times, or they have LLMs and their actual law school is accredited, we believe that it's completely okay to instill more stringent vetting procedures into the certification process. And so, like we said, it's not mutually exclusive to have a way to vet students and mitigate any possibility of letting people in who shouldn't be. And certainly, I don't want to propose the idea that someone who has failed the bar exam 2 or 3 times won't be great lawyers. Perhaps there are other ways to examine their competencies and apply it writ large. So we understand there are some concerns about people who have failed a few times or who are not from reputable law schools, but there are ways on the back end that we think can still certify properly.
And just to add on to the LLM question real quick, our petition actually calls for some sort of mechanism that's created to allow for LLM students and members of the APR 6 law clerk program to have similar access to diploma privilege, because upon completion of these programs, they are eligible to take the state bar exam just like JD students. And so it would only make sense if there was some sort of mechanism to also ensure that these students have an opportunity for diploma privilege, and especially for LLM students who are many times from international or are international students, they need answers right now because their visas may be expiring. And so we do think that that also should be considered.
Thank you all. We're gonna just to let you guys know who's in the queue. I'm gonna have Chief McElroy. I'm gonna have Governor Clark. I'm going to have Governor Grabicki. But in the meanwhile, and this just to insert a little extra dialogue in here, we have a few comments. I'm going to read a few of them. This is from Audrey Murphy, a 3L at the UW Law School. I'm currently tuning into the Board of Governors meeting right now. I think it may be helpful to note that most bar classes are scheduled to begin mid to late May, and many students from our state will need to make travel accommodations well in advance of the exam. With that in mind, I think it would be very helpful to students if a decision were made by early May or sooner rather than June. She also had an additional question about video surveillance, online monitoring of the bar exam. We discussed that earlier. That question was raised. Chief McElroy related that is something under the control of the Unified Bar Exam. There's also another comment from a JD candidate at the UW School of Law. The majority of us have been living and working on the brink of not being able to afford rent. Just because a Rule 9 can be paid doesn't mean we are being paid a livable wage. I would not be able to work in the legal industry and afford to live as a Rule 9 without student loans. And then I will go now to Chief McElroy, and then I'll be reading comments from Governor Clark, and then we'll move to Governor Grabicki. Chief McElroy, please proceed.
Thank you. I meant to lower my hand, but I do want to echo the comments, thanking all the law students for their great presentation. It was very well done. You've represented yourselves well here today.
Thank you. And then I have a written comment from Governor Clark that I've been asked to read into the record on his behalf. First, I would like to highly encourage whatever decision that has been made that WSBA treat the APR Rule 6 law clerk graduates the same as law student Juris Doctorate graduates as far as any Rule 9 limited license that was granted, and or any other deviations from the standard process. My own parenthetical note, Governor Clark is the liaison to the Law Clerk Board. I believe it is very important that we treat the APR Rule 6 law clerk graduates the same as traditional law student graduates with regard to the bar exam and any potential deviation from that. I strongly believe that the practice of law isn't something that should be automatically granted when someone graduates from law school or the APR Rule 6 program. It is a privilege that an applicant earns after passing the bar exam, showing that the applicant has the minimal competent legal skills to practice law and not harm the public. This is why we have a bar exam. It's there to ensure minimal competency to practice law. I believe that we have a duty to keep the public safe in the regulation of the practice of law. Ensuring that we license competent attorneys and other limited legal licensed WSBA members should be our paramount importance. I'm not in favor of any waiver or limited practice right other than the Rule 9 for students to become licensed without passing the WSBA bar exam. It would be extremely unwise, in my opinion, if we passed the request before us and allowed current students to just be grandfathered into the WSBA as members without passing a bar exam. This request ignores the fact that no pandemic-19 virus and 30 to 40% on average of applicants do not pass the bar. What does that say? It says that our state does not deem the applicant to meet minimal competency requirements to not be a harm to the public in practicing law. So I'm strongly against diploma privilege. Also, if we were doing this for the class of 2020, what about other applicants that are retaking the exam? How is it fair to give them their request, but not others that graduated prior to 2020 then want the same request? Ultimately, I would ask we move ahead and try to hold the July bar exam if we can reasonably feel it can be administered. If not, and or as an alternative, I'd suggest we look at a fall bar exam as well, or extend the July exam until the fall as we continue to examine what is the new norm with regards to COVID-19. Also, in regards to the previous Rule 9 comment regarding compensation, I know at least that Yakima County Prosecuting Attorney's Office, we typically do pay Rule 9 applicants who intern in our office. The only time we do not is when a Rule 9 interested party wants to volunteer for our office to gain experience. And now, I got one more floating in here. If both a July and September exam are offered, how will it be determined who takes what exam? That is from Kate Gelbrand. McElroy, do you have an answer to that?
Well, that's a question that we need to work out. But my first thought was that if we can make it an option that the applicants could choose whichever exam they want to take as the first step, and then we would make arrangements from there to comply with social distancing requirements, that would be my personal preference, but my personal preference doesn't necessarily control. The second option would be what some states have done, which is to limit the number of people who can sign up for the July exam. And at that point, we would probably, since the applications are pretty much closed already, we would have to probably say, if there's a size limit total, first come, first served for July, and if others go to September. But I really honestly think that we would be able to figure out a way. As I said, I did a shout out to Gus Quinones when we started this. I'm just going to pass on to you that every time I talk to him about this, he says, Jean, you're stressing me out. But I have ultimate confidence in our ability to work this out and make things work in a way that can satisfy all the needs. Unless we're told that we all have to stay home, or unless we're told that we can only meet in groups of 10. I mean, I think those would be two very difficult combinations to get around.
Thank you, Chief. And I also have utmost confidence in the WSBA to achieve any task the court lays out for us. Next, we'll move to Governor Grabicki.
Thank you, Rajiv. I start with the premise that it is quite unlikely that we will be able to gather several hundred law students in one facility to take the bar exam in either July or September. If you listen to the epidemiologists, it's fairly clear they don't think that's going to happen. And therefore, I think we are looking at an alternative. I'm concerned with the diploma privilege because historically, we have a failure rate on the bar exam of somewhere between 15 and 20%. Not everybody who graduates from law school has yet acquired the necessary competency to practice law. Most, but not all. And so the thought that occurs to me is this. What if we dropped out this year, dropped out of the national program, and went back to the administration of Blue Book essays, which we did for years, let them do it at home in front of a Zoom screen, just like this. I think we could put that together. I think it's technologically possible. We would be examining the students. They would have an opportunity to get past the bar this summer, and we would be fulfilling our duty to the public.
Chief McElroy, I know this question just came out of left field here, but do you have any initial thoughts upon receiving those thoughts?
Yeah, it used to take the Board of Bar Examiners approximately a year, sometimes more than that, to put together a good exam. In addition, when we did the diversity and equity study comparing the Washington bar exam to the uniform bar exam, the results actually showed that the Washington bar exam was slightly worse for applicants from historically underrepresented groups. Slightly, very small difference, but slightly. And the remote, unless it was open book, remote proctoring just does not ensure exam security or lack of use of other materials.
The LSAC is actually, just to put some information out there, they're actually doing exactly that, doing remote proctoring for the LSAC. And I know it's not the same thing, but I I think that if the LSAT can be administered remotely, then we can figure out a way to administer the exam online, especially students who are immunocompromised, not risk it.
I think it's interesting. It raises a question we dealt with a couple of years ago, which is moving from being one of the last holdouts of having our own unique indigenously administered bar exam to moving to the national system, of which there are many, many strengths and advantages, which is why we moved that direction. But obviously, there's always benefits to local control over a process, which we don't have in this case. My queue is empty unless, Chief, your hand was raised for additional comments.
Yeah, it was just to address the remote proctoring issue. We just had a very long meeting about this yesterday. And the NCBE is, they've pointed out there's a big difference between a high stakes licensing exam and a qualifying exam or a law school exam. They pointed out all the ways in which you cannot guarantee that somebody's not cheating. They also talked about how, once you take a break from the exam, you've lost all control. You can't make sure that the environment that somebody's taking the exam in meets their accommodation needs. There just are a whole host of problems with using remote proctoring now at this point in the development of the remote proctoring system for a high stakes licensing exam that lasts 2 days. So it's really not a very viable option now. It'd be great in the future. I'm sure it'll get there at some point or a different way of administering the exam, but it just isn't something that would be allowed at this point. For a UBE score. There's no way that they would allow that.
Thank you. Now, having seen no more furious waves at me, and having seen the first round of virtual hands go around, okay, I see one. I have 3 people who have indicated, or at least at some point, who have spoken already, who have had their hands up, and I'm coming back around to that. And Governor Stevens had his hand up at one point, but lowered it. Did you still want to be in the queue, Governor Stevens? And I see Justice Whitener. I didn't hear from you, Stevens.
Yes.
Okay, great. So my next order is going to be as follows. I spoke earlier as if she'd already been sworn in, but I guess Justice Whitener hasn't quite been sworn in quite yet. But Justice Whitener will go first, as she has not spoken yet. And then I will have former SBA President Hudnell speak in response to something. And then I will have Governor Stevens, Justice Yu, and Governor Knight, and Governor Grabicki. So, Justice Whitener, please proceed.
Thank you. My question is to the Chief, and that is, what is the most number of people that can take the exam that complies with the protocols we're operating under? And has anyone considered, if you take that number of individuals, let's say at the Tacoma Convention Center, you have social distancing and all of the other protocols in place, and then also find other venues to accommodate all of the students who are taking the bar examination, and you provide the exam at the exact same time, but just different locations to comply with the protocols we're working under. Has that been considered?
That is exactly what we would attempt to do, depending on what the limitations are. Like I said, at one point before we got to stay at home, there was a 50 people per location limitation. If it were something like that, it would be relatively easy to do. 10 people per location would be, quite a bit harder. We might be able to pull it off, but it would require a lot of proctors and spaces. So yes, that's exactly what we would probably end up doing, is finding additional locations.
And the reason, if I may follow up, the reason I ask is if you're doing 10, and yes, of course, you'll need more proctors and more locations, then can you utilize, instead of like the convention center, utilize some of the law schools or other locations such as those with your proctors so that the students can be wherever they're located? For example, if they're in Spokane, they don't have to come to Western Washington to take the examination.
Yeah, so that is another one of those security issues that we talked about yesterday, and the NCBE normally discourages that because of the difficulty of trying to make sure students in their own home schools aren't accessing materials in places that we just can't guarantee are secure. However, they did say in this situation that it is an option, and it is something that we would certainly be willing to talk to the law schools about. If we got to that, yeah, definitely.
Thank you.
Thank you both. Next, we'll go to Governor Stevens and then Justice Yu.
Thank you, Mr. President. Well, first of all, I took a look at the ABA resolution, and one, I think the resolution undercuts the proposals that the law students are presenting, because it really speaks to limited licenses, and it even speaks to a defined period of time in which that license would be good, and actually says, and actually I think indicates in 2021 that people would then come back and take the bar exam. You know, as I listen to this discussion, I'm sorry, but everything seems to be, there seems to be no give and no balancing of the various concerns. And so I am sorry, I'm one of those who can't support the idea that because of this time, one gets to just become a lawyer for all time, never have to take a bar exam. I'm also not sure, and I agree with Governor Grubicki, I am not sure, one, that we can really look at July. And I'm also thinking that in terms of even some of the alternatives that you might impose, you probably need, at the shortest period of time, September, to actually put those things in place. Again, not to try to do everything to make these adjustments by July. And but I'm really concerned that you know, we're trying to if I understand, and please to the three L's who are present, if I understand, this all centers around the bar exam in July. And maybe the answer is that we're not going to do that. And maybe the answer is that we have to have an alternative time. And maybe the answer is, and until that time happens, it is not the best of all possible worlds, but there is a period in which maybe 3L, I mean, maybe Rule 9 is an answer, and Rule 9 with some concern being given regarding what people are paid. But, you know, I think July is just one too soon, but I also think it is not a fair result that because of this crisis, this pandemic, we're just going to allow a whole category of graduates to become lawyers forever and all time and never have to come back to actually sit for the bar, even when we're past that period of time. I think that's a bridge too far.
Rajiv, this is Kim. Can I get in the queue, please?
You will be in the queue, and you haven't spoken, so I'll even move priority around a little bit. But you know, there's few times in a legal career when there is a justice about to speak, and you get to shove them out of the way. Justice Yu, you'll forgive me, but I skipped over earlier former SBA President Hundell, who I promised was going to speak, and I skipped over him. So, President Hundell, please proceed, and then we'll go to Justice Yu, and then Governor Hunter and Peterson, and then I'll resume my list of governors who have already spoken.
Thank you, Mr. President. I apologize, Madam Justice, for jumping in line. I just wanted to very briefly respond to comments made by Governor Clark, I believe, concerning the merits of the bar examination and the 30 to 40% first-time failure rate. I want to first and foremost say the ideal outcome here is we test in July, the class of 2020 is admitted to the bar based on our passage, and we move on from this thing. What we're talking about is a contingency plan. What if we cannot take the test? And for several reasons that we've already talked about in depth, postponement of the bar unduly burdens the class. Alternative methods of admission to the bar, but by taking it later on, burdens the class. I think what we're talking about, we're afraid of the 30 to 40% that we think might not be able to practice law, and we are burdening the 60 to 70% that would otherwise be ready to practice law, represent their clients, do good in the community. I think the easier solution is not to wholesale turn this thing off and then try to figure it out down the ways. On the back end, it might be easier. And our petition is somewhat silent towards what that looks like because, frankly, we lack the subject matter expertise. What would a system look like of evaluations on the back end once you're admitted to practice? Granted, it's kind of scary. There's some wiggle room there. There's a lot of uncertainty for sure, and there's a lot of harm that could be realized. But ultimately, we're talking about disqualifying an entire class because of a fear of the 30 to 40% that we think might not be eligible to practice, when really we're measuring one's ability to take a test. I don't want to get too much into the merits. And again, our petition is not asking for waiver to other metrics of evaluation, such as the Washington law component, the character and fitness evaluation. These are indeed things that would measure an applicant's ability to ethically practice law. We're just talking about the UBE and its exposure to substantive law that a graduate gets prior to practicing law. That can be done in many, many ways.
This is you.
I just want to jump in really quickly. I'm sorry.
Hold on, Tiger. I'll come right back to you. Okay. I'll put you in the queue. Just as you.
Thank you, Mr. President. My question is primarily to the governors and to you, and that is, what's your process going to be like in terms of decision making? Will you be discussing this and then providing the court with a recommendation, or I'm just sort of curious what the next steps are for you as a body?
That's a great question, and I think you're in the midst of our process. And I personally thought, given how late this came in, the best way to help the court is actually to have the court here and hear the governor's individual comments directly, hear our questioning of the students, give you an opportunity to talk to the students, hear from our chief regulatory counsel. Again, I'm here to facilitate the conversation of the Board of Governors, so they may want to try to come to a consensus today. But I thought it was valuable for the court to hear all the different perspectives that might be present on the board, which isn't always reflected when we come to a 7-6 decision and send an advisement to the court. But we may, in fact, get to that point today. I haven't heard any motions being thrown down yet, and I'm glad we're having this conversation. But this is our sausage-making time.
No, and may I just wanted to say thank you for inviting us to listen to the comments, because I think it does make a difference. And I do want to thank the students for taking the initiative, for being creative, and putting the question before us. I can't say where I am because I just don't know. I'll do that in deliberation with my own colleagues, but I do appreciate the fact that you had the courage to raise the question. So thank you.
Thank you, Justice. Now, Mr. Kuhn, did you have something very important to add there in response?
Justice Dio, I'm so sorry. That was completely on accident. I just wanted to quickly add in, and also Governor Stevens, completely respect your position. I think at this point, from the student's perspective, it's not a battle of the minds anymore. There are good reasons to have the bar exam. There are also very good reasons to not have the bar exam and pursue an alternative route. At the bottom line, what we're asking for is that the well-being and safety of students, as well as our future careers, are placed first in an impending recession and pandemic. We know that having the bar exam could prevent some people who shouldn't be practicing from going through. We also know that diploma privilege will ensure the most equitable outcome and ensure justice for a lot of clients who need to be served right now. And if we were to pick one side, from a student's perspective, we think choosing the compassionate route is the right response in this crisis.
Thank you. Now we're going to go to two governors who haven't spoken yet, Governors Hunter and then Peterson. And then we're going to hear from Chief Justice, and then we're going to hear from Chief Justice Stevens. Yes, Governor Hunter.
Okay. I just want to say again, I'll echo what everyone else has said, that this has been a very good presentation and lots of thought and research has gone into it. I do, however, have a couple of things to say. I agree with Governor Stevens' assessment of the situation. On the basis of qualification and equity, I think to allow individuals to go forward and practice law without benefit of the bar exam licensing and licensing process would be not only a disservice to the public potentially, but also to individuals that sat for the bar exam and studied for the bar exam and had to go through it before they were granted the privilege of a bar license. I sympathize and understand when it was mentioned that having to work while studying for the bar could certainly be a challenge. I know that there are numerous attorneys that did that, including myself. I was working full time and I studied for the bar and passed, thank God. And also, I know that with the upcoming recession, which I think is inevitable, that there is going to be some struggle with employment. And I can also speak to that because while I was waiting for my bar results, I couldn't get a position as a Rule 9 because of the competition. So I worked at a restaurant to fill the interim and to pay my bills. So there are options available. Sure, it's inconvenient, it's potentially crippling, and I appreciate that. But this is a very significant, unusual situation. However, I think that certain things cannot be allowed to go forward without the practice and process that has been well established in this state. So I do think that we need to be flexible with trying to work out an arrangement to allow those individuals to take the bar exam. But I, like Governor Stevens, am not in favor of granting licenses without benefit of passage to the bar exam. Thank you very much.
Thank you. Governor Peterson.
Thank you, Mr. President. I still remember back when I was a law student, and it's a lot of work, it's a lot of money. And, frankly, the students deserve, at least in my mind, to have certainty that the bar exam is going to happen so they can, get ready to start studying for it and take it. I mean, obviously that has to be done in a safe way. I mean, that kind of goes without saying. And in some way, it'd be helpful, I think, if somebody was able to talk to the governor now and see if we can't get an exception for this test. This is not a social event. This is kind of naturally social distancing, right? I mean, they're going to be sitting at tables. We can make sure they're segregated. We can have people continuously cleaning the bathrooms. I mean, I just, I think we can do this in a safe way. And if we can get the governor to say, hey, I'm going to give you an exception to do this exam, we do the exam. I think, this discussion really shows all the problems we create if this exam doesn't happen in July. People start working, and then they have to stop into September. I mean, that's not what employers want. We're not doing the employers any good service here. We're not doing the students a good service here. I mean, I think if it's all possible, even if it means begging the governor to give us an exception, we should do that, and we should get back to the law students ASAP and say it's a go or not go so that they know what to prepare for. Thank you.
My begging success rate is pretty good. But next we'll have Chief Justice Stevens.
Thank you, President Majumdar. First, I want to say, just to express my appreciation as well to the student representatives who helped put together the letter and petition and who are here today presenting, because your efforts really have focused to be able to have this conversation at this meeting. So we recognize, I think all of us recognize, this is an important and urgent issue and you deserve an answer quickly. I want to just update everyone on what the court's process will be. We have en banc our administrative meeting on April 29th, so that's Wednesday after next, and this is on our agenda to discuss. We do expect and hope that we will have updated thoughts from the bar about your plans, contingency plans, considerations, a recommendation if the Board of Governors decides to make that recommendation. As we all know, under the APRs, the WSBA, is responsible for designing how the bar exam goes forward, but of course the court is the only entity that can determine whether there is a bar exam. So we're really looking for that guidance. In addition, we have had outreach from the deans of Washington's 3 law schools. I believe they're working together to put together some thoughts that they'll submit in writing as well, and that they may be soliciting input from students on that. We welcome further input from students, if there are additional, some of the questions that have come up today. Upon further research and reflection, you may have some additional information you want to share, and that would be absolutely welcome. We all know this is a national issue. It's been under discussion most of the spring since we've been in the public health emergency. And Justice Susan Owens is our court representative to the NCBE, and she is helping. There's a lot coming out through the ABA and the NCBE, and helping gather some of those updates from what is happening in other states and what some of the considerations are. So the court wants to be fully informed when we take up this discussion, and that may include circling back with additional questions. But I did want to assure the students that we recognize the immediacy of having an answer to this question, and that among all the options, there are no perfect options, and there's a lot to balance. Certainly your futures, all that you will provide to the people you serve, our responsibility in overseeing admissions to the bar, so much on the table, and we will make our best efforts to come up with a fair and equitable solution and to get that answer to everyone in a timely fashion. So thank you.
Thank you, Chief Justice. Next, we'll have Governor Tollefson, who has not spoken, and Justice Owens, who has not spoken.
Can you all hear me, I hope?
Yes, thank you, Governor.
Hello? Okay. Well, first of all, I want to thank the third-year law students for making this presentation. It was wonderful to review the materials and to listen to your remarks. Really, thank you very, very much for being here. I do have a quick question, if I can ask it of our Chief Regulatory Counsel. Maybe I didn't write it down in my notes, but did you make a recommendation or no? Did you have a recommendation that you wanted to share with us or no?
I have not made a recommendation yet. I think the most equitable thing to do would be to try to go ahead with a July exam, but I also recognize that that may be the one thing that's impossible. So yeah, that's the bind that I find myself in.
Okay, and I got one more question for you. So what roughly speaking does each of these bar exams cost that we do in July and February?
So the location, the Tacoma Convention Center, just the main rooms themselves run somewhere in the neighborhood of I think $24,000, $25,000 per exam. That provides space for a number of different rooms in there, including the main site. And in addition, we rent rooms in a nearby hotel that we use for special accommodations, et cetera. Cancellation of the July exam, if we canceled outright, we would pay half of that cost for the Tacoma Convention Center. So that's around $12,000 to $13,000. To reserve a new room, If we held the exam on September 30th and October 1st, there would be no cancellation cost for the July exam. We could just transfer the money straight over and hold it in the Tacoma Convention Center. If we went to the September 9th and 10th dates, or if we went to smaller venues all over the place, we'd do our best to find free and see where that gets us. I don't have an actual total cost yet for those options.
Okay. Okay, and just my final comment. I want to listen to everybody more about this, but I got to tell you, I'm leaning towards the expensive option, which is July, September, and February. And the reason for that is we're lucky enough that we've accumulated a budget surplus, and these are absolutely challenging times, unusual times. And if we're going to do anything to try and help the people who want to take bar exams out, I think we do it with maybe the most expensive option because, well, I can tell you, there's no guarantee that you're going to be a great lawyer if you pass the bar exam. I had a relative who became a judge who did not pass the bar exam the first, in fact, I think even the second time he took the bar exam. I had colleagues when I was down at the Supreme Court as a law clerk one who went to an Ivy League law school didn't pass the bar exam the first time he took it. So you can see stuff going both ways on this, but I still think it's probably a good idea that we hold a bar exam and try and just maybe make it available more than 2 times in the year. Thanks.
Thanks. And just as a precaution, Treasurer Clark, I know you heard words threatening your budget surplus. So if you have any heart medicine nearby, keep it nearby there. I should tell the story sometime of the time the bar negligently thwarted me by telling me I failed the bar exam when I hadn't. But next, I'd like to go to Justice Owen, who is on mute.
Am I unmuted now?
Yes, Justice.
Going back and forth. Yeah, I represent the court on the UBE and have for many years. And I can tell you from knowing these people that there won't be a July exam if there's danger or health risks to students. I'm convinced of that. My understanding, and Chief McElroy, you might have better contact or more recent contact, is they would make a decision in early May about the July contact or exam, and then there are lots of alternatives, and so it would just be a matter of them weighing what would work for them. I spoke to the BCE rep from Oregon yesterday, and he says, like us, they are prepared to go forward in July, and they have a lot of alternative proposals if it does go forward, some of which we have if you read the materials that were submitted. There are different rooms that can be isolated. You could, I don't know, they came up with a number 250, but they normally have, like we do, 500 people taking it, and they didn't know if 250 would be considered the group size, or if it would be the whole group, even though they were in different rooms, would be considered the 500. So there are a lot of details like that need to be worked out, but that's where they're coming from. They also looked at the one idea that we haven't seemed to have explored, was having the law schools administer to their own students. That was not a popular option for them, but they have explored it and looked into it. And of course, the other problem with that is out-of-state students don't get to take the law, get to take the exam in theory. So I think if Judge McElroy or Chief McElroy, I really appreciated the materials. There were a lot of them, but it really, I want to congratulate you and your staff for thoroughly vetting this and taking it very seriously, as the students have also. You students are very good advocates. I'd probably let the three of you in, but for someone who took the bar twice in Oregon and in Washington, it's inconceivable to me that you could become a lawyer and not have to go through that torment. Thank you.
Thank you, Justice. And then I have a governor who hasn't spoken yet. That's Governor Higginson.
Thank you, Mr. President. I find myself very sympathetic to the law students, knowing what it's like to be worried about where you're going to be able to find the money to pay your rent and so forth, which happens to all of us, or a lot of us, I think, when we graduate from law school, whether we have a pandemic going on or not. So I am entirely sympathetic to that. However, I don't think, for all the reasons my colleagues have stated, that this is a good road for us to walk down. I'm also concerned about how it would play out with regard to malpractice coverage. We've talked about that. I know the court has that under consideration right now. And if people are a Rule 9 legal intern, my understanding is that they are covered by their employer's insurance. However, if they are allowed to practice law without passing the bar exam, I don't know exactly how that works. And then if they take the bar exam later and they don't pass it, does that give rise to some kind of an automatic claim on behalf of the people whose cases they worked on, who now say, well, now you flunked the bar, you're not really a lawyer. Were you a lawyer when you were working for me? Was there a standard of care violated? I don't think that that's a good place for us to be on behalf of the clients who are the public that we serve. So with all of that said, I would like to move that we respectfully reject the proposal brought to us by the law students and allow the bar exam to proceed, and asking that the court if they will, contact the governor to ask him to clarify that if the bar exam is held under proper circumstances, it is not going to violate his stay-at-home order.
I'll second that.
Yeah, hold on. Let me just be clear. Governor Higginson, were you talking about something kind of board action, or were you just talking to the court?
No, I'm asking that the board, I've just made a motion for the board's consideration that we respectfully reject the law students' proposal, and that I guess to be clear, that we forward our recommendation to the court with a suggestion that the court may wish to consider contacting the governor to clarify that the bar exam could be held without violating the social distancing rules.
Would you mind if those were bifurcated?
No, that's fine. So do you want me to just make the first part of the motion then?
That would be great.
All right. So I move that we respectfully reject the law students' request that has been presented to us.
Okay. And I heard a second from Dan Clark. Is that still accurate, Governor Clark?
Yes. Mm-hmm.
Okay. There's a motion on the table. Any further discussion? I have people in line still, so I'm just going to go ahead and call them. Governor Knight?
Thank you, President Majumdar. Yeah, I do have further discussion on Governor Higginson's motion. I absolutely agree that the best case scenario is to hold the bar exam safely in July, perhaps also hold it in September. But that really would be the ideal result. And so I guess part of the discussion, and maybe this is a question for Jean McElroy, part of our discussion, I think, should be what steps can the bar take to help ensure that it's safely administered? I obviously recognize it's not administered by us directly, but we do play a significant role in providing the space and that type of thing. So what is the seating capacity of the Tacoma Convention Center? How many people have signed up to take the bar exam? And basically, how far apart can we get everyone in the Tacoma Convention Center to take the test under kind of the normal circumstances?
Right. So we have, I believe, about 624 people who've registered so far. When all is said and done, that will shake out to fewer than 600. there's, it always surprises me, but there are a lot of people who drop out in the last week or just don't show up. And so the Tacoma Convention Center main room can seat 1,000 people with 2 people per 8-foot table. So if you figure 6 feet, eat one person to a 6-foot table, say, or you space it out differently so everybody's 6 feet apart, you get pretty close to the number that would be in there. Not all of those 600 will be in that room. We have a separate room that we could put another 100 or 150 max into. And we have some smaller rooms that we seat our special accommodations folks in. So all told, in one room, which can actually be divided into 2 rooms, also that one room, I'd say we can easily handle 550 in some combination of rooms there.
Okay, and just to make sure I understood you correctly, with the number of people that's registered and with the venue we currently have booked, it is possible to seat everyone at least 6 feet apart. Is that right?
We're having that discussion with the Tacoma Convention Center now, but I believe the answer to that is yes, just given the spaces that are available.
Thank you.
Thank you. Governors Grabicki, Nancy and guest star Justice Gonzalez. Governor Grabicki.
Thank you. First of all, thank you to Carla for making the motion. I do think that we should have a vote today so that we can indicate to the court where we stand as a body. I continue to believe that we will not be able to conduct the regular bar examination in July and probably not September. And I think that we need to start planning for that eventuality, hoping that it doesn't happen, but we need to be prepared for it. I think that something that Alex Stevens said is very important. We're in a very difficult time, and we have to exhibit some flexibility here. And to me, the flexibility means that we have to back off the rigidity of security that we normally embrace. To me, if we had to go to a blue book examination and it had to be open book in these really awful times, that's better than doing nothing. And I think that we should be thinking about that alternative in the event that we can't hold an examination in the traditional sense.
Thank you, Governor Grabicki. Governor Cicchetti.
Yeah, just briefly, although I see the reasoning behind moving forward quickly and making a decision quickly, I also think that if it was clear today that we could not hold the bar exam in July or August or September, then we would have already canceled it as of today. I think things are continuing to evolve. I think it's a little premature to reject the law students' proposal when I don't think all of the information, we have all the information before we can make a decision. So whether or not I believe that the law students should take the exam or should not take the exam is kind of secondary to, I think, in my opinion, gathering more information and finding out if we can make a July, August, or September bar exam possible.
Thank you. And of course, I can always call more and more endless meetings. I have the power. You guys have vested me with the power to call more meetings. Justice Gonzalez. And just for the comment, I know there's a lot of public comments coming in, former governors on the public comment line by email, former governors in the room, members of the public. We're not going to have any more conversation from the outside. Limit this to governors and justice at this point. Justice Gonzalez.
Thank you. I respect that the governors will make a decision based on the best information that they have, and that the justices will have to make our decision when it comes to us, however that goes. And I appreciate this discussion very much. Currently, though, I want to say that I'm leaning in favor of the students' recommendation. because what I hear right now is a discussion about how we can make the bar exam work in the Tacoma Dome with 6-foot spacing. 6-foot spacing is not enough for a group that size. It's not going to work. It won't happen. I agree with Governor Grabicki about that there is a need now for flexibility and leadership, and that's what we need to demonstrate. The question, as I understood it from the students, is what if we can't do it safely? And I don't know how we decide that now if we don't know. Some of us think we can still do it safely. I'm in the camp that I don't think we can. There will not be a way for us to hold a group that large together, taking the bar exam over 2 days. So the question really is, what are we going to do if we can't administer the bar exam? I think that's the decision that we need to make. And we do need to make it quickly just because of all of the expense and hardship that we visit on these students if they're continuing to prepare as if we might be having them come to the Tacoma Dome in July. That's my 2 cents. I think that's the way we need to be thinking about it. But I very much appreciate this discussion.
Thank you, Justice Gonzalez. Governor Stevens.
So I wanted to make sure that I was not misunderstood. I do think, so for example, for Governor Grabicki, I'm not for the open book proposal either. But here's what I'm suggesting, and I'm going to support this motion by Governor Higginson. As I do so, I want to ask the law students for them to consider that they may amend their proposal because for me, as I said, the real difficulty I have is the idea of granting your proposal for all time. And that's problematic to me. I think you need to work that through. On the other hand, again, regardless of how this comes out, I would certainly hope that Regulatory Counsel and the Bar Association think about, which is why I said I also think September, because I'm not sure everything in Tacoma is a good thing. I'm not sure that we shouldn't be looking at least a site in Spokane, at Gonzaga. I'm not sure if we shouldn't be really thinking about how best to do this in a way that is safe if we have an exam in, and I'm going to say the earliest September, because I just don't think all the moving parts are in place. But I'm going to take the hard position on the proposal as it's provided to us, with the idea that we may even have further conversation for the court, but for the proposal as provided, with little flexibility in terms of what that means for any others before or after, that's why I'm going to vote for this proposal.
Well, first it would help if I unmuted myself. I'm going to ask that Chief Regulatory Counsel Mcelroy speak, and then SBA President Dasick speak. Thank you. Give us some final comments.
Thank you. I just wanted to ask a question to clarify. I did not understand the motion to mean that the exam would have to be held in Tacoma Convention Center. If that turned out to be an impossibility, and if we could make other arrangements to hold it in a different place. Is that accurate?
As the maker of the motion, I'll say yes, what you said is accurate.
President Dasick.
Thank you so much. I just wanted to clarify that while in our petition we did say that the only route we see that would be the most equitable for everyone is diploma privilege, it's not that we are outright saying that that's the only thing that we want. We just want all the things that we outlined in that petition to be considered going forward. And for us, we've done a lot of the thinking, the research, and talking with students who are from different backgrounds who are either immunocompromised, who have some sort of disability where they need to know the answers now, and that seemed to be the only option. However, we're not opposed in any way to working with different guidelines and regulations. In fact, I believe my peer Efren, he actually asked if we could just be considered and seen as partners in this going forward, so we can make sure that it's the students' voices that are the most important at this time. And I just wanted to make that clear. We're not saying diploma privilege or bust. We're saying we just really want to get the most equitable option for everyone.
Thank you. I'm not seeing any further comments. If there are no further comments, I'm going to proceed to taking a roll call vote. Oh, did I hear something?
Yes, it was me.
Governor Angeville, please proceed. However, you're muted.
Thank you, Mr. President. Sorry about that. And thank you so much to the students for their wonderful presentation. I want to say just no matter what decision is made regarding your petition and your proposal today, I hope that you understand that you're being heard. I really feel for you. I am the veteran of 3 different bar exams in 2 different countries. And it is a stressful thing to anticipate and contemplate. And I can only imagine what it's like not knowing. And I think you absolutely deserve to know what you're facing. And I just want to say again, however the vote goes with this one particular petition that you've put forward, please know that we're listening. And I hope, and I'm sure my colleagues will join me in saying that we want to hear your voices as we move forward to try to find a solution. I don't think we're going to find one today, but I think this has been a really productive dialogue, and I really appreciate that all of us are here together.
And with unmuting myself, without hearing any further desperate hand raising or scrabbling, I'm going to proceed to a roll call vote in alphabetical order with a correct alphabetical order list. Governor Abel.
Aye.
Governor Angeville.
Aye.
Governor Clark.
Aye.
Governor Grabicki.
Aye.
Governor Higginson.
Aye.
Governor Hunter.
Aye.
Governor Knight.
Aye.
Governor McBride.
Aye.
Governor Peterson.
Aye.
Governor Schicchetti.
Aye.
Governor Stevens.
Aye.
Governor Swagel. Governor Swagel. Governor Tollefson.
I vote aye.
Okay. 12 votes in favor, 0 votes against. The motion carries. I think the board will want to take up a question next, what it might want to further advise the court. But I believe, Governor Higginson, you had a second motion, correct, that you had made?
Yes, and the second part of my motion, and I don't mean at all to step on the court's toes because the court's well able to decide what they wish to do. But my second motion was a recommendation respectfully made to the court that they seek a determination from the governor that holding the exam in whatever way. You know what? Before I make the motion, the reason I'm hesitating here.
Governor Higginson, we've been charged with administering the bar exam. Might I suggest your motion be directed to us seeking the governor's permission rather than trying to the micromanagement of the bar exam onto the court?
Okay. So my motion is that we, being the Washington State Bar Association, through our president, contact the governor of the state of Washington to request that he clarify that the bar exam may be held in July without violating his social distancing rules.
Is there a second?
I'll second that.
Thank you, Governor Peterson. I have some discussion. I have some hands raised. I have Governor Clark, and I have Chief Justice Stevens.
Would it be, I'm just wondering, given the court's plenary power to regulate the law and separation of powers issues, I would personally believe that the court could order that the bar be held, the exam, and I'm wondering if that might be something that the court would want to do. Thank you.
I imagine they have to discuss it, but as a coincidence, we have Chief Justice Stevens next in the queue.
Thank you, President Majumdar and Governor Clark. I think that's an apt observation. As you know, courts are recognized as critical infrastructure, and regulation of lawyers by the court is part of our essential operations. So for the same reasons that essential bar functions continue and essential court functions continue, I do believe the court has plenary authority. And certainly, I think what we need to look at then is what's safe, what social distancing. But I do not, just as a trial court does not need permission from the governor to have an in-court proceeding that might involve 10 people, I don't believe the court needs to seek permission from the governor to hold a bar exam. I think we need to do it. I think that is within our defined authority. So that's just what I wanted to comment on. But recognize that many essential things are occurring that allow people to violate the general proclamation because it's an essential function. But obviously the critical question is we must do it safely, right? Just as we knew that even when 50 were, people were, when the regulation was no more than 50 could gather, that doesn't mean 49 gathering was a good idea. So, we're going to look at this with health and safety in mind. That's all I had on that.
With those comments in mind, Governor Higginson, my plan would be to be briefing the court on our health plans and safety plans, which are subject of a great deal of public comments coming in that I'm not putting forward, and ask the court to take that as their position. If you want to amend your motion or if you want to withdraw your motion, that would be the course of action I would try to lead us on at this point.
I would actually like to, with my second's permission, withdraw the motion and substitute a different motion, which I'd be prepared to state.
Please state it.
All right. I would like to move that consideration be given to holding the bar exam in July in the safest manner reasonably possible, which would include holding it in smaller, across the state, perhaps at law schools, so that there's less travel issues for the students that might wish to take the exam.
I'll second that.
I think Governor Peterson was the original seconder, so it sounds like he's accepting that motion that we've all decided it's a constructive. I don't know what we decided about Robert's Rules of Orders, but that's it. It's been seconded and amended as Governor Higginson has stated it to direct. Well, I'm going to interpret as we're directing the bar staff to examine and, if possible, make multiple locations for the July bar exam. Is that accurate, Governor Higginson?
That would be a perfectly good restating of my motion.
Okay. Let me just ask Chief McElroy a real quick question here. Are we violating any court rule by asking you to do that, or is this something in our authority to ask you to enact?
I think you can ask us to do that, yeah.
Great. I have next in the queue Governor Alex Stevens.
Yes, my only question regarding this motion, because we are so focused on July, I'm wondering if we should not say July or the subsequent bar exam. Otherwise, my question would be, so suppose for whatever reason, we can't do it in July and we still have these orders. I mean, isn't the concern continuing at that point?
That's a great question. My assumption was that if we learned that the July bar exam wasn't able to be heard, I would be summoning all of you and probably inviting the justices again to rediscuss this issue and inviting the students as well and the law schools about what the best course of action is. I know Chief Regulatory Counsel Mcelroy has in her copious materials laid out some alternatives. I imagine we'll have to decide on one of those alternatives. And maybe today's the day we want to do that, and maybe we want to see what happens in the next couple of weeks. Chief Regulatory Counsel Mcelroy.
I just wanted to say that I do like the flexibility of being able to consider moving it to September if the July exam is obviously impossible.
And Mr. President, I would accept that as a friendly amendment to my motion if my second would accept it.
I accept that.
I don't think your motion excludes that, though, do you?
Well, I said July, so I just wanted to be clear that if we were talking about moving it to September, that would be fine.
Sure. Okay, any other comments? Not seeing anyone. We got a nice little thank you from our out of state law student Daniel Kim. He had to leave, as did Justice Yu. Not hearing any more questions. I'm going to move forward with a roll call vote. Governor Abel.
Aye.
Governor Angevel. Governor Angevel, who's on mute.
Sorry about that. Aye.
Governor Clark.
Aye.
Governor Grabicki.
Aye.
Governor Higginson.
Aye.
Governor Hunter.
Aye.
We're getting good at this. Remember our first Zoom meeting and I had to call people's names like 10 times? It was great. Governor Knight.
Aye.
Governor Knight.
Oh, just after you said we were getting good at it, too.
Yeah.
Aye.
Governor McBride.
Aye.
I messed up the flow. Governor Peterson.
That's going to be a hard yes.
Governor Schicchetti.
Aye.
Governor Stevens.
Aye.
Governor Swagel. Governor Swagel. Governor Tollefson.
I vote aye.
12 votes in favor, 0 against. The motion carries. We will be directing the bar staff to look at multiple exam locations for the 2020 bar exam. So Governor Higginson didn't say 2020. That's my interpretation of what. Very good. Is there any
Mr.
more?
President?
Yes, Governor Stevens.
Yeah, and so I'm going to ask this as a general question first, and that is, would it be in order, or are we taking note? And I'm looking at Jean especially, but there was a concern that I'd like to make sure we give a sense that the Regulatory Council will work with both the law schools and the law students in helping develop a process that works for everybody. And maybe I don't need a motion to do that.
Yeah, I've been in communication with the law school deans previously. We have another telephone call set up for next week, I think, and they are in constant communication with their students, I believe. So we make that.
Well, if you can bring them to the table, it's one thing to have the schools speak, but I think we want to also have the students at the table where they can weigh in.
And I hate to speak on everyone's behalf or hearsay, but it's my understanding, Chief McElroy, that all 3 law school deans are urging the July bar exam to go forward. Is that accurate?
That was the position that they stated in our previous conversation. Because things change so quickly, I wouldn't want to speak for them at this point.
Of course. So we are still on this topic. Is there any more discussion on this topic? I'm going to report to the court, though some of them were here, and Chief Justice was here. In fact, the majority of the court was here. As to the results of our discussion, I've already forwarded the court all our materials and all the students' materials. I will forward them all the public comments we've received, even the ones that I was not able to read and get through. People know that the court will be considering this issue on their 29th en banc hearing. We will be directing our bar staff to look at multiple exam sites, pending that the July exam can happen, and I think we'll know in about a little over 2 weeks here what the state of the governor's orders are going to be. I thank you all for participating in this, and frankly, I thought it went really well. Our first full Supreme Court, not that everyone came, but full Supreme Court justice invitation and participation in the discussion. I thought it was very helpful to get the issues to the key policymakers, but the key rule creators of our justice system, and I thought that went very well, and I thank you all for your participation. We have a lot of other exciting stuff on the agenda today, and I'm going to probably take them out of order just because we have some other guests coming here. And yes, students in particular, our SBA President Dasick and former SBA President Hudnell, if you have any closing remarks, I'd welcome them.
Just want to say thank you guys so much for hearing us out and, for taking this matter so seriously. I know this is such a big decision for everybody, and we completely understand how hard this is. This must be on you guys to have to figure out. So I just want to send my sincere gratitude to all of you for taking it so seriously. Thank you guys, and thank you guys for letting us speak here today.
I'd like to echo that, if I may. Thank you sincerely, not only on behalf of myself, but on behalf of all those that we're representing today, for seriously taking time to consider our situation, our plight, if you will, and those that we're seeking to serve at some point. We ask that you keep us in mind moving forward in the days and months as we navigate this situation. Obviously, there's a lot up in the air, and no one knows what tomorrow might look like, let alone in July. But we sincerely look forward to working with the Washington State Bar Association. We are not adverse. We don't see ourselves as adverse. We see ourselves as collaborative. And we hope to be tapped as not necessarily subject matter experts, but as individuals that are kind of living through this first. So again, thank you so much for everything that you're doing.
Well, the two of you are all of the students are in our hearts and minds, but the two of you in particular, I really appreciate your leadership roles that you've taken already in your student body leadership roles. I hope when you do join our bar association, which I'm fairly confident you will, I hope you get involved in the WSBA and bring your leadership skills to our table. And if you don't have jobs lined up, I think you did a pretty impressive performance today. You might want to send the resume around to the Board of Governors. All right? Have a great day, and thanks for joining.